Good morning, everyone. Thank you for being here today. My name is Diana Schulach, and I am the program manager at Family Focus Resource Center. I work at the Cal State University Northridge office. We help families that have children or young adults with disabilities. And we also have three other offices that are located in the lobbies of the regional center offices for North LA County. So that would be our catchment area, which is Antelope Valley, Santa Clarita Valley, and Chatsworth. So today we have with us David Terk from Serenitas Special Needs Planning. And he's going to be presenting to us today a beginner's guide to special needs planning, which is a very important topic for everybody who does have a child with a disability. So I'm going to go ahead and turn it over to David. If you could please hold on to your questions till the end. We will have a Q&A session at the end. If you do want to write your question in the chat so you don't forget it later, please feel free to do that, but we won't be addressing questions till the end. And we do pause the recording for questions, so your question will not be recorded or shared. And anything that you put in the chat can also not be seen in a recording. After David will be sharing his slides with us, so you will be receiving the slides as well in an email after this workshop, along with a survey, a brief survey on letting us know your thoughts and any suggestions for any future workshops. We always value your opinion. But you'll receive the slides, the survey, and also the link to the YouTube channel in case you would like to watch this presentation again, or if you'd like to share it with somebody. So right now I'm going to go ahead and pass it over to David. Thank you so much for being here today again, David.
Thank you for having me again, Diana. I appreciate it. Nice to, well, see your screens over here. All right. So here's the screen. I think we got it. For those of you who haven't been here before, my name's David Terk. I'm the executive director of Serenitas Special Needs Planning. Um, we are a special needs planning firm. We have over 40 years experience providing services exclusively to the special needs planning community. Um, so a lot of people, special needs planning often comes up and people think about special needs trust first. And while crucial, there are so many elements that go into proper planning, legal planning being one of them. So let me start. Special needs planning is not something that you prepare now, place on the shelf, and forget about until you die. You will be pleased to learn that many of the things that we talk about today will be of great value, both now as well as in the future. So got to switch screens here. Hold on. There we go. So our objectives today are number one, to help you understand the current and future planning issues that all families ultimately have to address. To provide you with the information, resources, and tools to be able to take action and prepare a plan. And finally, we want to be able to assist you in overcoming any of the real or perceived obstacles and help make the process simple, affordable, and finished in an efficient amount of time. So, when you leave our workshop tonight or today, you will have all the information and knowledge to be able to make life decisions on behalf of your loved one, be able to prepare a plan with the necessary documents to assure a smooth transition, security, and life while giving you and other family members peace of mind. So this is the first, maybe second generation. Now we've been doing this long enough. This is the first generation of persons living with special needs who will typically survive their parents. Therefore, planning is no longer an option, it is a necessity. In the past, most people with special needs did not enjoy a full life expectancy. And this is no longer the case. So, for instance, 100 years ago, one living with Down syndrome had a life expectancy of under 10 years. By 1950, it had increased to 30. And today, persons living with Down syndrome live to 60, 70, even in their 80s. People with special needs are now typically surviving their parents and other family members. The result is that planning is no longer an option, it is a necessity because, in all likelihood, your loved one will survive you. So I'm often asked, when should we start planning? And while it is somewhat self serving, the answer is now. Whether the person is 4 or 40 years old, who will know what to do for your loved one tomorrow if you're no longer here? If you've have you done everything so that you can be assured of their future care, supervision, security, and quality of life? Without being too melodramatic, if you did not make it home from this workshop, well, obviously you're home now, but you know what I'm saying. What would happen in your loved one's life tomorrow? How would it change? Who would be the first people contacted? Will they know what to do? Do you have a will or a special needs trust, and where are they kept? Have you created a directive letter with all of the information about the care of your child? Have you shared that with current and future caregivers? Are you aware of what government benefits your loved one is now and will be eligible for in the future? And who will provide care when you're no longer there? These are all the questions that we have to ask. A lot of times we avoid it, but ultimately we have to face these. So, families, everyone understands the importance of preparing a plan, but why don't people? There are all sorts of reasons, all of them listed here. Many, it's too emotional and we don't want to deal with it. Some are hoping our loved ones will be cured, or they're too young and we don't need to worry about it. We've got other concerns. There's worries about money. Do we have enough? Or our state isn't large enough. And it's also confusing and no one seems to know exactly what to do. I get conflicting information. So all of these reasons are valid, and we need to overcome all of these in order to move forward. So the planning process addresses 4 areas of life that affect anyone living with special needs. There is legal planning, government benefits, budget and financial planning, and lifestyle planning. All these things go together. They interlink. Without any one of these, we have a plan that is likely going to falter. So let's start by talking about some of the legal planning issues. These are some of the more complex issues that we want to make sure that we address. So there are 3 primary documents that all work together. There is the last will and testament, there is a family trust or revocable living trust, and then there is the gold standard for proactive planning would be to utilize a third party irrevocable living special needs trust. And I know that's a lot of words, and all of them do make a difference. There are different types of special needs trusts for different purposes. So let me briefly start at the beginning. Not all of the slides are going to necessarily be relevant to exactly what I'm talking about at this moment. So we're just going to pause this one right here. I want to start with the last will and testament. This is a public document which enables a person to state their wishes as to the distribution of their assets. It appoints executors or personal representatives to settle the estate and appoints guardians for minor children. In our documents, we include appointing conservators for adult incapacitated children, authorizing the last serving guardian or conservator to appoint his or her successor, and to specifically be able to exclude people whom you do not want to have any involvement on your loved one's behalf. In California, under 18 is a guardian, and for those over 18, they're conservators. These are interchangeable in different states. Some it's guardian for everything. But if you hear guardian or conservator in California, guardian is under 18 and conservator is over. So while we're on the topic, many parents actually don't realize that when their child with special needs reaches the age of 18, they no longer have any legal authority to make decisions for their child. Um, in order to retain your parental rights, one would have to go through a court proceeding called a conservatorship, and where we would petition the court to maintain um, parental authority for our child living with special needs. If conservatorship is not an appropriate avenue, then having sets of powers of attorney for anyone, any adult over 18 is appropriate. So, oh, one more thing about wills. They are a matter of public record and subject to probate, which can cost anywhere from 10 to 20% of the value of the estate. In California, it can take 18 to 24, maybe longer months to settle the estate. This will not work for the person living with special needs that must maintain government benefits and be able to have money accessible for care immediately. So the next, let's see. All right. We're going to get into the special needs trust. I'm just previewing with the other documents here. Okay. So all of these things, again, have to go together. Your first document is the last will and testament. And there are, just so you know, specific terms in traditional wills and family trusts that need to be addressed to allow the creation and acceptance of a special needs trust. I just want to leave it there, but it's not just any boilerplate will or trust that um, that will suffice. It is not about legality necessarily. That is one level, but that's really the lowest level. It's the only reason one needs to do this type of planning is to be able to maintain benefits for our children and protect those assets from any lawsuits and creditors. Um, it is crucial that Social Security interpret our documents favorably so that we are able to maintain those benefits and they interpret those documents properly. That's really where the secret sauce is with the special needs trusts and all of the other documents that go into your plan, is that Social Security approve them. Now, the great news is when you do have a properly drafted plan, Social Security can review your plan now while you're alive. You may never have heard this before. This is very unusual information, but there is such a thing in Social Security as a trust review department. And that is their job, is to review trusts and make sure that they are valid for individuals to be able to maintain benefits. So all of this we know. We've done this for many years. Our documents have all been reviewed. And again, when you have yours properly done, you can voluntarily bring them to Social Security for their seal of approval. Okay, so now let me jump into the family trust quickly, and then we'll move on to the special needs trust and the nuances there. Um, the next legal document is known as the Revocable Living Family Trust. This is a private document. It is not subject to probate, its costs or delays. It can hold assets for your heirs until you wish them to be distributed. So, to make it simple, it allows you to say who gets what when, under what circumstances. Perhaps you have a child that you feel would not be responsible receiving a large sum of money all at once. In your trust, you can leave instructions that the inheritance be portioned out at different increments. For instance, maybe some at age 25 and some at 35, so that we don't make lottery winners out of our younger children. Oh, excuse me. Plane mode. Okay, sorry about that. Um, the assets in a family trust are not exempt from lawsuits and creditors, not in your revocable living family trust. Trusts are not community property, and they will protect the inheritance for your heirs. So, while the family trust benefits typical children, it will not work for the person living with special needs. Assets in the family trust are considered a countable resource to all beneficiaries. If they are considered to belong to the person receiving benefits, this could result in loss of eligibility for benefits and potentially trigger payback to Medi-Cal. Many families, this is where many families are, they're thinking but don't understand the nuances. Many families indicated that they plan to leave their assets to a typical sibling and that sibling will be in charge of whatever money is there. And while that technically can work, it is fraught with difficulty because what if your typical child gets married and then divorced, and all of that money is not protected? Half of that money will now be in the hands of the ex spouse and no longer available for your child living with special needs. So we share this with you as a cautionary note um, of that many people try to do that and it can create a lot of problems. Um, okay, so moving forward, to remedy these types of situations from assets being considered to belong to any individual, it's important to identify that who the individual is, that they are a person living with special needs, and that it is your intention that they receive no distributions directly, and that any distribution intended for them should go to their special needs trust dated April 17th, 2025. Okay. By doing that, you are telling the reader, most specifically Social Security, that we know what we're doing, that my child lives with special needs and is receiving benefits, and we know that they can't have money directly. And we're saying so in our will and in our family trust that anything meant for them goes to their special needs trust. And this is a way to help assure that the planning you've done upstairs translates into the real world. Okay. So we've hit on the will, we've hit on the family trust. Most of us have heard of those, but there are differences in the details. Now we're going to start on this slide here that's been sitting up here tempting you forever is the special needs trust. Okay. So the special needs trust is where you can put assets aside for your loved one, where they are protected, where they can maintain government benefit eligibility and allow you to provide management of the funds. The gold standard for proactive planning is to utilize what's called the third party irrevocable living special needs trust. I stress all those words. I think I mentioned earlier, all of them make a difference. There are different types of special needs trusts for different purposes. And when we're being proactive, meaning mom and dad are actively, we haven't passed away, we don't have the good problem of having received money in our own name, and we are able to direct what happens. Third party means that the money funding the trust is coming from anyone in the world except the beneficiary, your child with special needs. Okay, that's third party. Why is that important and how does that differ than first party? So let me start with third party means that it's being funded by individuals who are not receiving that government benefit, and therefore there is no payback to Medi-Cal associated with it. And that is the difference. In our world, we would like to be able to preserve the resources for our family, be able to maximize the government benefits that our children are entitled to, and be able to preserve any resources left over for other children, family members, so that we can direct it the way that we want rather than having that money go back to pay for past services rendered by Medi-Cal. So that is why a third party trust is used. is there is no payback to Medi-Cal required. Okay, so that was the first one. Third party. Irrevocable means that it cannot be changed. Now, in our documents, there are two elements that can be changed, and one are the successor trustees, and the other are the beneficiaries or remaindermen of anything left in the trust after the person passes. However, everything else is locked in place. And the reason is um, if Social Security is going to be able to review your trust, it has to be irrevocable. If it were changeable, they could review it, put their seal of approval on it, and then give it back to you, and you could change it 5 minutes later. So it does have to be irrevocable. And then Social Security can review it and give their seal of approval. And then it has to be living, meaning that it exists. There are different types of trusts. One listed here is called the testamentary trust, which we'll get to in a moment, but that is not a living trust. That goes into existence after someone passes away. Okay. So just to remember, when we're being proactive, we want to be able to utilize a third party, irrevocable, living special needs trust. However, that begs the issue. What happens if my child receives money directly and that's first party money and it's over $2,000 and it's going to impact their benefits? Okay, so let's say a child receives grandma and grandpa pass away and leave $80,000. We call this a good problem. Yes, it affects our benefits, but if we know how to handle it, we can handle it. So a first party trust is one that will allow us to be able to, for the individual, your child who's received an inheritance or any sort of money that's accrued, can go into this type of trust. So in California, they're known as a disability trust or a Medi-Cal payback trust. Federally, these are known as OBRA 93 special needs trusts, this one down here at the bottom. In 1993, Congress put into effect this type of trust, which allows individuals with disabilities who receive too much money to put it into this type of trust. Their benefits would be maintained throughout their life. They would have access to the proceeds in the trust. And then only after they passed away, anything in this payback trust would go back to Medi-Cal before it went to any other recipients. So it's still a good deal, but in a perfect world, we would prefer there not to be payback to Medi-Cal. Um, Typically, there are a lot of questions that come up around this. Jot them down. We'll touch on all of it. I'm trying to be comprehensive in this, but we are shoving 4 hours of information into about 45 minutes, so we can't hit everything. Um, One thing I want to draw your attention to, and one of the big red flags that we see on a regular basis are special needs trusts created as testamentary trusts. Okay. These are the ones that are created inside of one's existing family trust or revocable living trust. It's not to say that it's impossible for these to work, but they're highly doubtful because anyone that understood how Social Security was going to interpret these documents would not construct it in this way. And typically, these types of trusts, I mentioned earlier about the specific terms in the will and the family trust that give authority to all beneficiaries, of which your child will be one. And unless that is specifically addressed, Social Security will interpret anything in the family trust to belong to all beneficiaries, which again will make us ineligible for benefits. You wouldn't know that. The attorney who put this together, they did their best, but didn't know that it's perfectly legal. However, it's the wrong tool for the wrong job as it relates to Social Security and preserving benefits. And that's why in our special world, everything works a little bit differently. Um, and it's enormously important to do this the right way. Okay, so we've touched a lot on special needs trust. We have the standalone trust, which is again ideal, that third party irrevocable living trust. We've talked a little bit about that testamentary trust, which if anyone has documents already that has this type of trust, I'm happy to review them and let you know what it is you have and how you might want to approach things moving forward. Okay. All righty. These are some further key points regarding special needs trust is that they're never in the beneficiary's name. It's in the name that assets are in the name of the trust. The funds are only supplemental to what Social Security or government benefits provide. They are meant to supplement, not supplant. Okay. The just a couple letters difference, but it makes all the difference in the world. Supplemental needs, not to replace their benefits. The money cannot belong to the person with special needs, and the trustee has sole discretion in distributing those funds. These are all crucial details that have to exist in order for it to work. Okay. So now, when we talk about comprehensive special needs planning, I mentioned that legal planning is one aspect, but that is not the only aspect that we are talking about. There is government benefit coordination and um, budget and financial planning and lifestyle planning. All of these things go together, and these are the elements that all work together. Guardianship or conservatorship being this last one. One of the biggest questions that I cannot solve for any individual is regarding trustees. Okay, let's talk a little bit about who trustees are. The root word of trustee is trust. They don't have to be related, but we need to trust the person who we name as trustee of our family trust or special needs trust. There are, if we don't have family individuals to serve in that capacity, there are professionals who exist called fiduciaries or professional trustees who exist who can serve that role and be named in your documents to do so. If one does not have anyone to name, or they have little or few assets, there is another option, and this is called a pooled special needs trust. POOLED, like a swimming pool, where we pool individuals' assets into an aggregate so that they can achieve some uh, economies of scale on investment, and they can serve as the trustee for a special needs trust. These are typically run by nonprofit organizations. In Los Angeles, there are a couple of them. One is called, or in California, one's called the Golden State Special Needs Trust or Pooled Trust, and then there is a um, Jewish Federation Special Needs Trust as well, which uh, you don't have to be Jewish to utilize that, but they exist in order to help families in that situation. Okay. So when we have done proper, let me go back for a moment. I'm sorry. Um, I wanted to talk a little bit about government benefits. My slides are a little out of order. Here we go. SSI. So SSI is the first benefit our children will receive. They become eligible at age 18 as an individual, not necessarily as a part of your household, even though they might live there. 2025, the California maximum for benefits is $1,206.94. That can be reduced for any number of reasons. Typically, the most common reason that's reduced is that the person is living at home and not paying rent. And because they're not paying rent, and that means that you're paying for it in some fashion, that is a duplication of SSI benefits. And they'll reduce your full benefit by a third. So that $1,200 becomes 850 or 900 or so. Um, so that begs the question, well, can I charge my child rent? And the answer is yes, you can charge your child rent. And in this case, from a financial standpoint, you should, because if you do, there's more money coming into the household than there would be. And this can be accomplished. A lot of times we'll go into that Social Security interview and they'll ask you, let's say, well, hi, nice to meet you. Um, how is Bobby doing? Or, oh, Bobby's great. Here's Bobby. Nice to meet you. Where does Bobby live? Oh, well, he lives at home with us. Oh, that's great. Does Bobby pay rent? No, Bobby doesn't pay rent. How would he? He's living at home with us. And the Social Security people say, oh my goodness, you are the nicest parents in the world. For that, we're going to reduce your benefit by a third. That's not what we wanted to hear. So simply by telling them that you will be charging rent or they need to pay rent, um, that will allow you to receive a full benefit. It is very easy on the back end. There is a special letter that you can send called the confirmation letter for rent that you can send to Social Security that will give you a full benefit. For anyone who would like a copy of that, please email me. I do want to have a little discussion about it so you know what to expect. But if you are receiving $850, $900 a month from SSI and your child is living at home not paying rent, or even if they are paying rent, and I would assume the Social Security is not picking that up, then it would behoove everyone to submit this letter to receive a full benefit. And just like that, just by attending this workshop today, you may receive another 400 some odd dollars a month. Wouldn't that be great? Okay, so SSI is a temporary benefit. It is available, whoopsie, in anyone receiving $1 of SSI automatically receives Medi-Cal. So some of you may already have Medi-Cal through the regional center waiver, institutional deeming waiver through the regional center. That's okay. What would happen is that waiver, when your child receives full Medi-Cal, they'll get straight Medi-Cal. The waiver would go back to the regional center to be used for some other person that is medically eligible but wouldn't qualify financially. So they're part of a family that wouldn't qualify. Um, so now you'll be on straight Medi-Cal and receiving 1,200 some odd dollars a month. Then, when one of three things happens to a parent, that benefit will change from SSI and will migrate to what's called SSA, which doesn't stand for anything, but that's the survivor retirement benefit that your payroll would be withheld and paid to Social Security. That's your money. That's not social safety net money. That's your money. So when a parent retires or becomes disabled, a child becomes eligible for 50%, 50% of that person's full retirement age benefit. That is in addition to, not taken away from, your benefit. In addition, after 25 months on a parent's survivor retirement benefit, is under the what's called the Disabled Adult Child Program under SSA, DAC, Disabled Adult Child. After 25 months of starting that benefit, receiving 50% of a parent's retirement, they become eligible for Medicare as well as Medi-Cal. So now we have two levels of insurance. And while we're talking about health insurance, you should also know that your child is not kicked off of your private insurance at age 26. As a person living with a disability, we are able to stay on a parent's insurance as long as that parent has insurance. Okay. Now, not every company knows this. It doesn't happen automatically. So I always recommend when your child is 25, a year before that switch would happen, make sure to talk to HR. Tell them my child will be turning 26 this next year. What paperwork do you need me to fill out? What's the process to make sure that my child stays on the healthcare benefits? Okay. If you get some younger person, 22 years old, just out of college, doesn't have a lot of experience, they won't even know that this exists. But that's why these workshops are important. It does exist. And this was law many, many decades before the Affordable Care Act came in, where they raised the age of being a child on a plan to 26. That's what we seem to remember. So, again, your child can stay on your private medical insurance as long as you have that insurance. They are not kicked off at age 26. All right. So now, under this scenario, we started at age 18. We're receiving $1,200 a month from SSI, and we have Medi-Cal, and then our parent retired, and we're receiving half of that benefit. Let's say that's $1,500 a month. Dad had a $3,000 benefit. He retires. That's 1,500 coming to the child living with a disability, and 3,000 to dad. That's 4,500 in the household. After 25 months, our child receives Medicare in addition. And then when a parent does ultimately pass away, we want to maintain our Social Security benefit, and that will go up to 75% for life. So, whatever that full retirement age benefit is, let's say it's that $3,000 number we used, that would be $2,250 a month coming coming in, which will offset whatever other expenses we have. And the more that comes in from the government, the less has to come out of pocket. That's why this is so important. Um, let's see, is there anything else I need to share with you on this? I can't think of it right now. Those are the key points. All right. So moving on, government benefits. Now we're on the downhill slope. This is a quick conversation. The exercise is a little harder to do, but it's easy to talk about. We need to know, what does it cost for my child to live on a day-to-day basis and for us to provide the quality of life we want them to have. We need to, so that gives us our expense number. Then we need to identify how much we can maximize out of the government benefits and subtract that out of there. And then that becomes the number that we want to fund. And that's going to tell us what our monthly budget needs are. And then we need to project forward, and we use the crystal ball and we say, okay, in 20 years, we want to apply a certain rate of inflation so that we know that a dollar today isn't worth a dollar in 10 years. So we need to make sure that there's enough money there to cover the costs in the future. Okay. So that's the only thing I'm going to talk about financial planning. Everyone is different. Everyone has different resources, different benefits. Um, Everyone's child has different needs. So there is zero cookie cutter answer for any family. Everyone is individual and specific. But we have a lot of general rules that we want to stay within these guidelines in order to be able to accomplish what we want to accomplish, which is to protect our child, make sure their benefits are in place, and that we have a plan as to who is going to care for them and where they're going to live. And that's where this letter of intent will come in. Now, this letter of intent is not a legal document, this is informational. And this is as or more important than any of the stuff we've talked about already. This is all about who your child is and what makes a good day versus a bad day. Is it buttons or zippers? Is it scrambled or fried eggs? Who are our doctors? How do we communicate? How do we interact with our activities of daily life? Eating, walking, etc. Everyone is different. We want to be able to share this information with current and future caregivers. So I'd like to end with a story about a gentleman named John who came to our office a little over 10 years ago. John was 42 years old. He was oxygen deprived at birth, uses a wheelchair, and had the mental capacity of a 3 year old. His parents had passed away. His sister and brother-in-law came to visit us. He was lucky that he had a caring sister, and they wanted to talk about planning. And during this meeting, John gets this huge smile on his face and starts rocking his head from side to side, saying, Bubba, Bubba, Bubba. I said, well, what, what do you need? And she says, what do you think he's saying? And I didn't want to embarrass myself and play the guessing game. I said, I don't know. What is he saying? She said, he's saying bubbles. I'm like, okay. Bubba, bubbles. Maybe I'll get there. Okay. She says, so I just like, do you have bubbles in your purse? You like, who doesn't love bubbles, right? She says, no. He likes the feeling of soda bubbles going down his throat. And not just any soda, Pepsi. So it's a cute story, but it gets you thinking about what would happen if John came to my house, to Uncle Dave's, and I'm excited. I want to be helpful. I want to give him the life that we intend to give, but I don't have any instructions. And John, I don't understand what he's saying. And let's say I figure out Bubba is bubbles. It's not blowing bubbles and it's not chewing gum and it's not a bubble bath. And John keeps saying Bubba, and I'm not finding what it is he wants. And then ultimately, John stops asking, especially because all I have in the house is Coke. He's never going to see a Pepsi in my house. So we want to be able to share that John loves the feeling of Pepsi soda going down his throat. And that when he says Bubba, this is what he wants. And how can we make sure that that is communicated so that John can have that one piece of joy in life that he's able to ask for? That is why doing this thoughtful planning is so important to you and your children. It allows you to be able to set a plan into motion and to be confident that it's well thought out and going to do what you want it to do. It allows you to have peace of mind, knowing that your child's benefits will be preserved, that you've identified who are going to be there to care for them, and that they are safe. So, your next steps: write down all of your concerns and address those obstacles. You have all the information you need now to be able to address this planning. And you also know where to find me. So, why don't we pause for what I'm sure will be some questions?
Yeah, I'm going to go ahead and stop the recording now. Thank you so much, David. That was excellent. We do have one